Hello, everybody. I'd like to welcome you to today's event, a discussion on the nomination of Elena Kagan to the United States Supreme Court. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. And for those of you who may be unfamiliar with ACS, we are a national network of lawyers, law students, scholars, policymakers, and judges that promotes the vitality of the Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. Today we have an incredibly outstanding program for you. As you all know, on May 10th, President Obama nominated Solicitor General Elena Kagan to the United States Supreme Court, his second opportunity to name a justice. Today's panel will discuss what qualifications and experience would General Kagan bring to the court. What does General Kagan's record tell us about what kind of justice she might be? What can we expect from the confirmation process going forward? And finally, how should we expect a justice to apply the principles in the Constitution to today's cases and controversies? It is my distinct pleasure to introduce our moderator today, Amanda Frost, who is an associate professor at American University's Washington College of Law. And I'm not going to give you a whole lot about her background because you have handouts, but Amanda has quite an incredible record. She was previously a staff attorney for Public Citizen, where she litigated cases in the federal courts of appeals and in the Supreme Court. She clerked for Judge A. Raymond Randolph of the U.S. Court of Appeals for the D.C. Circuit, and she's worked on the Senate Judiciary Committee. Amanda is very dear to us at ACS as one of our most active scholars and serves as a real leader in the work that we do. So we are extremely pleased that she is here today to lead this discussion. So please join me in welcoming Amanda.
Thanks for that introduction, and thanks everyone to coming. This is a really important moment, even for those of you who are at the very beginning of your legal career in law school, perhaps here just for the summer. Even for those of you who at that stage in your career, if Elena Kagan is confirmed, as most people believe she will be a justice on the Supreme Court for the great majority of your legal career, as will the equally young Chief Justice Roberts and Sotomayor. So we're at a moment right now where we're thinking about one of an appointee to the court who may well be there for the next 35 years if she follows in the footsteps of her predecessor, Justice Stevens. And this is an important moment to think about not just Elena Kagan specifically and the qualifications she brings, but also the process more generally of selecting a justice to the Supreme Court. What do we want that process to look like? What kind of questions should a nominee be asked? What kind of background would we like a nominee to the court to have? And what would we look for when thinking about who would make a good justice? And luckily, we have a panel here today that can answer those questions, both generally about the process and how that process will work and perhaps how it should, things that should be changed about it, and also a panel that is familiar with the career and writing and work of Elena Kagan and can discuss the kind of justice that she might turn out to be. So I'm going to very briefly introduce the panelists so we can get right to it. They have longer bios that I believe you all have available to you, so I'll just highlight a few of the most relevant aspects of their biographies. To my left, we have Rachel Brand, who is counsel at WilmerHale. Rachel Brand was an assistant attorney general for legal policy at the U.S. Department of Justice. In that position, she was intimately involved in preparing Chief Justice Roberts and Justice Alito for their confirmation hearings. She also served in the White House counsel's office, where she was generally involved in selecting and prepping judges who were nominated by the president for positions in the federal courts. Next to Rachel, we have Walter Dellinger. He's chair of the appellate practice at O'Melveny and Myers. He is currently a visiting professor at Harvard Law School, and he's on leave from a professorship at Duke. And before that, he served as Assistant Attorney General and head of the Office of Legal Counsel and as Acting Solicitor General where he argued a number of cases before the U.S. Supreme Court. And then to his left, we have Thomas Wilner, counsel at Sherman and Sterling. He is head of the International Trade and Government Relations Practice for Sherman and Sterling. And in addition, he has served as counsel of record to the Guantanamo detainees in Rasool versus Bush, and he is also counsel in Boumediene versus Bush, two major cases challenging executive power and the right to detain suspected terrorists at Guantanamo Bay. So all three of these folks have a lot to share with us on their views of the Supreme Court nomination process, what we should expect a few weeks from now at the confirmation hearings, and how Elena Kagan might perform there and perform as a justice. The format today is going to be that each panelist speaks for about 5 minutes, 5 to 7 minutes, about the process and about General Kagan. Then we're going to open it up for a discussion among the panelists, and then we're going to turn to questions and comments from you all for the panelists. So please, as you're sitting here, be prepared and think about things you might like to ask the panelists for that last session of today's discussion. Rachel, why don't you go ahead?
All right, well, it's good to be here. Thanks to ACS for inviting me. So as the token Republican here, I know you're all expecting me to bash Elena Kagan, which I'm not going to do. I am going to make some observations about what I think Republicans may ask her at the confirmation hearing, and tell me if I'm not speaking into my mic correctly. And Amanda also asked me to talk a little bit about what might be going on right now in terms of preparing the nominee for the hearing. So I'm going to touch on both those things fairly cursorily, and maybe we can get into more detail in the discussion. But in terms of the hearing prep, every administration does this a little bit differently, and it depends in part on the preferences of the nominee, how she wants to be prepared for the hearing. But there are 4 major objectives of the hearing preparation. The first is to ensure that the nominee is not surprised by anything that is said or asked at the hearing. So the helpers in the administration, really it's fairly easy to predict what's going to be asked. You look at what the nominee has written or said on hot-button issues, because that obviously will come up. You look at transcripts of previous confirmation hearings, because given the longevity of tenure in the Senate, many of the senators on the committee now were also there for past hearings. They're probably going to ask many of the same questions. You have notes of what senators have been asking the nominee in the one-on-one courtesy visits up on Capitol Hill. They're likely to ask many of the same things at the hearing that they asked in those meetings. You know what the press is saying about the nominee. You know what senators are saying in the press about the nominee. And then in some cases, senators will actually write letters to the nominee saying, I am going to ask you the following questions. And so obviously you're ready for that. So if you're a lawyer helping prepare the nominee, you sort of mix all that together. You exercise some political judgment, and you can predict with a fair degree of accuracy what's going to be asked. So that's the first objective. The second is to help the nominee think about what to say in response to those questions. The nominee is under oath. The administration does not tell the nominee what to say, but the lawyers can help the nominee think through, all right, if you say this, this is going to be the follow-up question. If you answer question X, that's a slippery slope, and you may be expected to answer question Y, and you might not want to go there. How are you going to handle questions about issues that might come before you on the court? Certain issues are very freighted with the language about abortion, for example, is very politically freighted. And if you use one word, it might send a signal that you think X, and you might not mean that. And so those are the sorts of things that the lawyers are helping the nominee think through. There are, the third objective would be to advise on demeanor, how to sit, how to address the senator, those sorts of things. And then the fourth objective is to beat up the nominee as much as possible during the moots so that you get any frustration or outrage or indignation out of the nominee system during the prep so that she or he doesn't lose composure during the hearing. And that actually is critical. So that's just what I'll say about the hearing prep. In terms of what's likely to come up at the hearing, there's going to be a bigger focus than usual this time on whether she's going to provide views on issues that might come before her on the court. I know Walter's going to talk about that too. That's always an issue. Every nominee since Ginsburg, at least, has taken the basic position that they will not provide their own views on a question that could come before them as a justice. I personally think that's the right position because I think if a nominee swore under oath that she thought or she would rule the following way in a particular case, a litigant could reasonably ask whether she is open-minded if that issue is in his case before the court. But in her case, it's a little bit more complicated because, first of all, she's never been a judge and she doesn't have a huge track record of writings as an academic, and so senators don't have as much to go on and to get a feel for what kind of justice she would be, so they may expect her to provide more views in the hearing. And the second reason it's more complicated for her is that she actually wrote, after the Ginsburg hearing, criticizing recent nominees for not providing their views. And it's interesting, the language she used was fairly pointed. She said that the confirmation process had taken on, quote, an air of vacuity and farce because the senators weren't insisting on disclosure of views. And she called the hearings a, quote, peculiar ritual dance in which senators propound their own views on constitutional law, but neither hope nor expect the nominee to respond. So I'm sure that Elena Kagan and her advisors are spending a lot of time figuring out how she's going to deal with that during the confirmation hearing. And that sort of leads into a second issue, which I expect Republicans to bring up, which is sort of a lack of experience argument. I personally don't believe that one has to be a judge to become a judge, but the argument, I think, will be she's never been a judge, she didn't write that many articles as an academic, she never really practiced law until becoming SG a year ago, et cetera, et cetera. So I think that is going to come up. And then, of course, you'll have all of the hot-button issues that come up at every hearing will come up at her hearing, abortion, obviously. When she was a law clerk to Justice Marshall, she advised him against granting cert in a case involving access to abortions for prisoners because she said it could be a vehicle for making bad law. So no doubt senators will probe what she thinks bad law is and why she said that. She advised President Clinton when she was in the White House to sign a partial birth abortion bill that was sort of a compromise bill containing an exception for life or health of the mother. I think senators on both sides of the aisle may be delving into that. What does that indicate about her own views on abortion? So that'll be a big issue. Now, I think that she will probably try to find a way not to answer questions about that. With respect to her tenure as a law clerk, she said in her SG confirmation hearing that she would channel Justice Marshall when she was advising him. With respect to her Clinton White House documents, she may say, as John Roberts did, that when you're a lawyer in the White House, you're basically advising in the context of a president and an administration with established views on that issue. You're not writing on a blank slate. So that's a typical kind of argument for a nominee to make. If a nominee wrote something as a lawyer for a client, the nominee says, look, I was saying that as a lawyer for my client. That's not my own view. So those are ways that nominees try to get out of answering questions. All right, then you have the Second Amendment. As SG, she did not file a brief in McDonald versus Chicago, the pending case about incorporation of the Second Amendment. That's sure to come up. She apparently worked on an executive order relating to the assault weapons ban at the White House. That'll come up. Press recently reported about one of her memos to Justice Marshall where she was, quote, not sympathetic to a criminal defendant who made a Second Amendment argument against the D.C. firearms licensing law. So, again, those are all things that will come up. The Solomon Amendment, big focus. She signed on to an amicus brief with a bunch of other law professors arguing in the Supreme Court that the Solomon Amendment was unconstitutional. Now, the interesting thing about that is that it'll be very hard for her to get around answering questions about that because she can't say that she was a lawyer arguing on behalf of a client because she was the client. She was the amicus, one of the amici in that case. So she'll have to deal with how to answer that. And then the last issue I'll mention briefly is Citizens United. The president, that's the recent campaign finance case you all know. The president obliquely referred to that case when he made a statement related to Stevens' retirement, and he expressly referred to that case in announcing Kagan's nomination, where he cast her as siding with ordinary citizens against unscrupulous corporations. Those are his words. And he pointed out that she chose to make that her very first argument before the Supreme Court. Now, some commenters have suggested that he is saying there that she personally endorsed the government's legal position in that case and that she was personally, sympathetic to that. So again, it may be harder for her to avoid answering questions about her views on that case in light of the president's comments there. So I'll stop there.
Thank you, Rachel. Walter?
I disagree with Rachel about whether a nominee should be forthcoming in discussing legal, political, and social views. I agree with the position that Professor Kagan took in her law review article, which is not necessarily the position that nominee Kagan will take before the Senate Judiciary Committee. Back in 1985, I wrote on this in the New Republic that, and quoted from 10 years before that, Charles Black, who said that it has been a very long time since anybody with any knowledge was under the illusion that a judge's judicial work is not influenced and formed by his whole lifetime, by his economic and political comprehensions, by his sense, sharp or vague, of where justice lies in respect to the great issues of our time. And I think there's no reason why both the President and the Senate should not know that about a nominee. Washington named judges that supported his view of a strong, overarching national government, not those patriots who resisted ratification. Lincoln chose those who had a deep antipathy to slavery. Roosevelt, those who believed that the national government had the authority to regulate the national economy and to ameliorate the harshness of the industrial workplace. Reagan nominated judges when he had a Senate who agreed with his basic political and social views and views on the role of courts. I see no reason why the Senate shouldn't have access to the same information, and the best way is to ask the nominee. Very rarely do those questions that nominees do not answer, rarely would they ever take a form that would require a judge to recuse herself in the next term of the court. I'm not even sure that should disqualify the question. Someone's going to serve 35 years on the court. The fact that they might be disqualified is not, I think, a great burden. But I think you can put to one side any question of disqualification. A nominee ought to be able to answer any question that a sitting judge answers. We can answer. We know what Justice Scalia thinks about Planned Parenthood versus Casey. We know what Justice Stevens thinks. Why can't we know what nominee Kagan or nominee Roberts or Alito thinks about the same thing? They're not recused. The only time a justice has been recused in my lifetime that I know of for expressing a view was when Justice Scalia, in a public speech, spoke of this nutty litigation about under God and the Pledge of Allegiance in the Ninth Circuit. In that very particular case, came before the court and he recused himself. But that would be the rare exception. Those who, Elena Kagan has criticized those like Professor Stephen Carter who say, oh no, if they express their views then the people would weigh in and there would be sort of a democratic process of who got confirmed based on what the public thought, and that would be inconsistent with the independence of the judiciary. I think that's a fundamental category mistake. We believe in the independent life tenure of judges. It's an extraordinary aspect of our system to have independent life tenure. Nomination and confirmation is the democratic moment that precedes the independent life tenure of a judge. And the reason we would never allow someone to say, if you nominate me or confirm me, I commit that I will vote to reverse in a particular case, is that that extends politics forward into the future when one should be wholly independent in making up one's judgment. But to say that we can't ask or know or be influenced by what a justice thinks or a prospective justice thinks about the great social issues of our time is to extend the life tenure back in what ought to be a democratic process. The framers could have said the first set of justices shall name their replacements, like the College of Cardinals, and forever insulate them. But they didn't. They put it in the hands of an elected president and in the hands of the Senate in order to have that moment of democratic input. I think proper no matter who's won the presidency, and to be tempered if that president does not carry the Senate, that there should be sort of a meeting of the minds. But I see no reason why we shouldn't have a more fulsome discussion. That said, I don't believe that Elena Kagan's law review article, which I think is excellent, by the way, I think it's a good indication of what a sharp legal mind she has. Her law review article, Confirmation Messes, Old and New in the Chicago Law Review, where she criticizes the vapidity, is that a word? Vacuity of vacuity and
I think vapidity is a word, though.
vapidity. Well, whatever. She thinks that they changed it. some have said that she'll play a huge role because she's taken that view. Well, to me, that's nuts. Whatever the right answer is to the debate that Rachel and I have been having, neither of us would think that the right answer is that there's a special rule for any nominee who's written a law review article on this subject. That makes no sense. That's not law. That's not how institutional practice works. That would lead to the absurdity that a nominee who had written in favor of nominees answering questions should answer questions, but only from senators who have also written that it's appropriate to ask questions. You need a chart, but not from senators who've written that questions shouldn't be answered. There is an institutional practice, and indeed, this turns on itself because in Elena's article, she herself says, talking of Judges Ginsburg and Breyer and their refusal to answer questions, that both knew that they were playing the game in full accordance with a set of rules that others had established before them. The proposal that Elena put forward that nominees should be more open, one which I wholeheartedly support, even more aggressively perhaps than she does, was in fact not accepted as the institutional practice in the ensuing nominations. It failed basically for want of a second in the nominations of Robert Alito and Sotomayor, so that it makes no sense to have a separate institutional practice for a particular nominee. There's a lot to be said about Elena as a nominee, but I think I'll wait till we hear from Tom, because I'd like to talk about what the critique of her will be and what her answers will be and what her strengths are and not so strong points.
Oh, well, thank you.
Did you want to call on Tom, Amanda? I didn't mean to I didn't mean to seize the moderator.
I'm a senator
Well,
here, you can tell.
I'm sitting here listening, and I was not going to talk about the debate about whether a nominee answers questions in detail and in a forthcoming manner, but let me comment on it. And I'm less professorial, I think, than my colleagues, whom I respect enormously. I just don't think it matters much. The fact is we have a partisan Senate. For the reason people don't answer questions in a forthcoming manner is because one side is out there to try to get you. It's not an open debate anymore. It's become a sham process. I think the vetting process really takes place in the White House. The president knows who he gets. So it's an interesting, important debate for a democracy, but the Senate has become so partisan, I just don't think it matters, unfortunately. Let me say also, we were introduced as we were going to talk in substance about Elena Kagan and her positions, and I really don't know her writings and her thought process. I don't know her personally. I assume because she's a nice Jewish woman from the Upper West Side, she'll be okay, but you never know in these things. For the last 8 years, I've been involved in the national security issues, Guantanamo and other detentions of people suspected for grabbed and suspected of terrorist activities. And what I can comment on is the importance of Justice Stevens during that time. I think he has actually been the bedrock protector of constitutional principles, and there's some reasons for that. There have been really 4 cases that have come down. The Rasul case, which was the first one establishing the rights of the detainees at Guantanamo to have habeas corpus, basic review, an independent review of their detentions. And Justice Stevens wrote that opinion, and he said that the habeas statute passed in 1789, the first Judiciary Act, extended or applied to people at Guantanamo. He went beyond the statute, though. He pointed out that habeas really was a writ antecedent to statute that was integral to our common law heritage. It was a basic thing in American principles. And he pointed out that the application of the writ to the people at Guantanamo was really consistent with the common law reach of the writ. The same day that Rasul came down, which dealt with foreigners held at Guantanamo, the Hamdi decision was handed down, which was a U.S. citizen held in a military brig incommunicado without hearing or trial. And there are 2 questions, really. Can you hold a U.S. citizen in the military context without a trial or a hearing? And really the plurality of the court, in an opinion written by Justice O'Connor, said you can, but that person needs to have a fair hearing, needs to be able to confront the accusations against him or her before a neutral decision maker, need to have a fair hearing. Interestingly, Stevens dissented in an opinion in which he joined Scalia, which he said that military exigency does not allow the detention of a U.S. citizen without criminal charge and trial. That's the only way you can hold a U.S. citizen. Clear distinction about citizens, but still taking a position. This might bore you going through this, but I think these are important cases. In the Hamdan case came down next, 2 years later, in 2006. And in that case, the question was whether the military commission procedures instituted by the president for trying this guy Hamdan and others he would designate to try were legal. Not so much that they were constitutional, but whether they were legal. And Stevens, in a very long, rather tedious opinion, said that they were not. He said, look, military commissions are something you can have. They're born by military exigency, but that doesn't allow you to a wholesale jettisoning of procedural protections. And I should say, the first thing he did in this, he said, I'm not going to defer to a military situation. These guys are there and we can look at this, and I'm not going to delay it until they make their decisions. This is something we can deal with now. He said, you need to meet procedural protections. And he found that those commissions violated both the Uniform Military UMCJ Commission Justice Act and the Geneva Conventions, which are incorporated in it. And in both of those cases, he said, the most important thing is that they allowed somebody to be convicted when he wasn't even present and without seeing the evidence against him. And that was just not kosher. Now, it was left to Congress to recreate another law, which he did, but Stevens stuck out in that. The fourth case is a very interesting one, the Boumediene case. After we had won the Rasool case, establishing the right to habeas corpus, Congress, the same one that will listen to Elena Kagan when she goes up there, revoked, not the same one, but revoked habeas corpus, revoked the habeas statute. And the question in Boumediene was, did the people at Guantanamo have a constitutionally protected right to habeas corpus? The opinion in that case was written by Justice Kennedy. But Justice Stevens played a critical role. When we first, after we had lost before Judge Randolph, my friend, again, we went for cert. And the Supreme Court initially denied cert. And in a very unusual thing, several opinions were published on the issue of cert. And Kennedy, 3 voted for cert. Kennedy, joined by Stevens, wrote an opinion saying we're denying cert now, but if the government keeps screwing around, we'll be open to it. It was a critical thing. Linda Greenhouse wrote in the Times at the time that he voted that way because he was afraid if he voted for cert that when it went up on the merits, that Justice Kennedy would say, well, look, your remedies haven't been exhausted. So that he took a critical role in sort of a political role within the court in setting up the case. We then did petition for rehearing on cert because the government did indeed continue to screw up. And we got cert. Kennedy wrote the opinion and we won the case, saying there was a constitutional right. The point I'm making is he has played a critical role on these issues of the Constitution and national security. I am afraid of his absence. Elena Kagan, in her confirmation hearings for the Solicitor General, did make some, I think, ill-advised statements that we are in a worldwide war and that she would have no trouble detaining somebody, and this is a very critical issue that can come up, is it, can you capture somebody far away from a battlefield and hold them in a military context in the war on terror rather than through the civil justice system? She seems to have initially indicated that she would have favored that. That worries me. Even if she doesn't, there are other issues, though. Justice Stevens, because of his age and his background, had a presence on these issues. He was a decorated World War II veteran who, because he was, could look at some of these claims of military exigency and understand that a lot of them was just crap. And I'll never forget in the Rasul case that Solicitor General Olson stood up and he said, "We are in a war and we must defer to the president." And Stephen, just like this, said, "How does your argument depend one iota on us being in a war?" It really didn't. It was a pure assertion of executive authority. He had the presence and the experience to look skeptically on these things, and will be sorely missed. That's it.
Well, thank you. We've got a lot of material there to work with, and I'd actually like to pick up on what Tom was just talking about, and particularly get Walter's views. Rachel as well can weigh in on Elena Kagan's approach to the question of executive power, because she's been criticized from the left on the potential that she will not be as liberal as Stevens was, or as willing to check or limit executive power as Stevens was. What do you think about that?
I read and learn from Glenn Greenwald in Salon, and he is the one who found her views to be close to those of Bush, Cheney, Thomas, Scalia is the way he put it. I think that that's wrong. Elena's article in the Harvard Law Review, her most major piece of academic writing outside the First Amendment area, is not about the issue of whether the president can act in derogation of the laws passed by Congress. Indeed, she says, I think in something of an overstatement, that if Congress in a particular statute has stated its intent with respect to presidential involvement with agencies, that ends the matter. I think the president has some minimum constitutional authority to assert his own views of the Constitution. But her article is about a robust presidential control of the executive branch, that the president, in the absence of any particular statutory prohibition on the president doing so, the president can take authorities that are assigned to agencies and direct the agency how to do those. I do not think that's a conservative doctrine. I think that is a Franklin D. Roosevelt view of the role of the president in giving energy to the executive branch of government. And I think it shows something about how our political culture has moved during the years of President George W. Bush, that presidential power over the executive branch is viewed with suspicion by progressives, when that has indeed been what has driven the role of the national government under strong presidential leadership. And sure, we want the president to tell the MMA what they ought to be doing about licensing offshore oil. We want a president to give vigorous leadership in these areas and not to leave it to administrative agencies. It's the president that Elena argues that when the president does it, it gives democratic accountability to what the national government does when the president asserts authority over executive branch agencies, and it gives transparency. It's not buried within some agency. The president has taken a position, so that I consider that to be, she does have a view on executive power that some on the left are criticizing these days, but I think it's a view of a robust executive control over the executive branch. And indeed, the cases she cites for the proposition of presidential control, Chevron versus Natural Resources Defense Council and Hampton versus Mao Sum Wong, both cases that emphasize the president's authority to make judgments for the administrative agencies, are both opinions written by John Paul Stevens, who I think has a similar vigorous view of presidential control over the executive branch of the government. And what her article does show is deference to that. I think the other criticism from the left is that we don't know enough about Elena Kagan, and I think the comparison with David Souter is not apt in the following sense. If David Souter had clerked for Judge Silberman and Justice Scalia and worked in political and legal positions in both the Reagan and Bush administrations, that would be a very different David Souter. And actually, what you have at Elena Kagan is someone who clerked for Abner Mikva, Thurgood Marshall, and worked in political and legal positions in the last two Democratic administrations. So that certainly tells you a lot about, where her instincts are about social and political issues, and I think some more of that will be seen as more of her papers are released.
Well, oh, sorry, go ahead.
Well, I actually don't agree with the argument that who one clerked for indicates what one's views are, but anyway. I wouldn't, I don't, I'm not going to purport to have any guess about what kind of Justice Kagan would be on executive power issues, but I will say that I think one of the best sources of information about that might be whatever has yet to be released from the Clinton Library. I mean, when you're a lawyer in the White House, that's perhaps the best place in the world to opine on issues of executive power. And I didn't touch on this in my opening, but I think issues about access to documents are going to continue to be very hot. I mean, the Clinton Library is sort of releasing them seriatim, and I think if they're not all released in some reasonable period of time, with some reasonable amount of time for Republicans to prepare before the hearing, that's going to be a big blow up. So let's watch that.
Well, and this is a question, I think, Rachel, your comments actually, your presentation opened the door on this. Quite apart from whether she'll please the left or the right, what do we think about her background coming into the position? I mean, Tom mentioned how Stevens brought his experience as a World War II veteran into the argument with him, into debate and discussion with the other justices. And we know when Kagan was nominated by Obama, he said, "She knows how the law affects ordinary people." It's a quote from President Obama. And yet some people have said, how does she know that? She's been in the ivory tower and she's worked in the administration. So I'm just interested to hear all the panelists, but maybe starting with you, Rachel. What do you think about what a justice's background should be, and maybe more specifically whether Kagan's background has prepared her for this role?
Well, there are two interesting things about that. The first is whether this question about should the Supreme Court be filled with people who have previously been judges. I kind of like the idea of having a non-judge appointed to the Supreme Court. I've always thought that. So her lack of judicial experience personally does not bother me at all. But the other interesting thing about this, regular people background kind of argument is that it gets very close to this empathy standard issue, which, President Obama, he first talked about it during John Roberts' confirmation hearing. He made a floor statement where he said that he respected Roberts, he believed that Roberts loved the law, he was brilliant and all that, but he couldn't support his nomination because he thought that, in those 5% of cases, the law does not provide the answer, and the answer is supplied by what is in the judge's heart and the breadth and depth of one's empathy and so forth. Conservatives, judicial conservatives, disdain that idea. And it came up in Justice Sotomayor's confirmation hearing where she was asked specifically whether she agreed with the president's empathy standard, and she specifically rejected it. So I'm sure that Elena Kagan will be asked about that, and I think politically speaking, it will be hard for her not to also reject it because then she'll look more liberal than Sotomayor and so forth. So that's a related issue that I think will come up for sure.
Go on.
I feel really sorry for empathy. Empathy has been thrown under the bus, and I think that's too bad. I think what the president was intending to convey, I would embrace the E word fearlessly, but it's in some sense nothing more than what Oliver Wendell Holmes said. The life of the law has not been logic, it has been experience. And the whole notion of balls and strikes and judges as umpires presents a view of the Constitution that in some ways delegitimizes parts of our constitutional text and constitutional tradition. The 14th Amendment is a decision by the country after the Civil War to have the national government be the guarantor of privileges and immunities and life, liberty, and property of citizens against state governments, and with judicial review being fully understood at midway through our nation's history. Judicial review had been fully established at the time of the 14th Amendment. And it's clear that there was no list given of what were going to be the kind of liberties that states could not interfere with, what kind of justification would be needed. And much of conservative jurisprudence simply, I think, has a problem with the 14th Amendment. The text is open-ended. The framers chose not to include a specific list but to look to to judges, as had been then the established tradition for half a century, to supply content to the open textured phrases of the Constitution. And I would love to see, I'm not sure when it will ever come, a nominee, maybe a nominee that's already bound to know that he or she is going to be rejected, to go down swinging in defense of empathy and of the inescapable responsibility that the framers of the 14th Amendment placed upon judges. So I would like to see us fight back a bit on that.
To that? Okay.
Can I
Well,
go
go ahead, Tom. I don't want to. Yeah, go ahead. I'll
No, I
follow you.
was going to say, I was also going to quote the Holmes quote about experience and how important it is. I don't mind a nominee. I wish we had less nominees who were judges. I wish we had less nominees who were professors. Frankly, I think both.
Maybe one more.
No, I think there's a tendency among judges and professors to become too analytical, ideological, and doctrinaire. I think the most important thing for a great judge is to interpret the law to achieve justice. And often I think the issues, at least in the area I've talked about, were not that difficult. I remember Scalia asking, name one case where habeas corpus has been applied to an alien outside the sovereign territory ever. And you could argue that there have been, but the real point, there hasn't been a case the other way either. Do you deny people hearing just because of some mechanistic sort of geographical line, or do you do it because there's a practical reason? What is justice? At the end of the day, a judge needs to look at their experience and say, well, there are cases either way here. What is justice? And that's not a liberal or conservative doctrine. It's something that I think we have lost in looking at judges, and we debate too much in these ideological frames. Anyway, go on.
Well, so I didn't come here prepared to debate grand, subjects of judicial philosophy, but here's the problem with the Hart standard. So the 14th Amendment may have very broad terminology, but there are sources that one can use to interpret it. You have, the history, both precedential history and American history preceding ratification of the amendment. What was intended by it. You've got subsequent, judge-made precedent interpreting it. You've got, all kinds of legal sources that enable one to interpret the 14th Amendment. But what I personally think in my heart today, how is that a legitimate basis for making a decision? So if I thought that judges were, I can't think of anybody who I would want to put on a court who I thought, geez, whatever you think in your heart today, that's good with me. I mean, you can't, that's the problem with the Hart standard. Now, empathy, you could interpret that term to mean different things. I think nobody thinks that it's not important for a judge to understand the consequences of judicial decisions. I mean, Roberts talked about that in his hearing, talking about a judge should and does understand that his decisions have consequences in the real world, and it's important to know that. So one could interpret empathy to mean that you're not blind to consequences. But, like empathy could also mean whoever I feel more sympathetic with today, that's the person for whom I rule. That is not an appropriate standard. So the problem is maybe that empathy could mean lots of different things.
I take empathy to mean its dictionary definition, which is to be able to understand how the world looks to other people and how rules affect people in circumstances different from one's own. I'll give you an example where I think it's just one memo out of thousands that will be mentioned in the Kagan confirmation fight, and that is the one about the application for cert in a case in which a woman prisoner was denied access to abortion. That was to be at the prison's expense. And it has been portrayed by some, and Rachel mentioned this, as her saying that granting this case could lead to bad law on prisoners' rights or abortion, and so it's seen as Elena having sort of a left view on that. I read it the other way because she says in her memo, she actually criticizes the claim of the prisoner and says that since it's now established, was established at that time and now, that women who are not prisoners have no right to government funding for an abortion. How could you have funding if you're a prisoner? when women who are not prisoners don't have funding. Well, I think that ignores the plight of someone who's in prison and has no access to go and raise money, to do what's necessary. I think that one line, I don't want to place too much emphasis on it, to me shows in that particular instance, I would like to have seen a little more empathy, a more understanding of what it's like to be someone who's incarcerated without access to funding. So that's what I mean by empathy, that it doesn't mean that it dictates the result you reach in the case. You may still think that the Constitution guarantees no right of funding, but the ability to understand the different position that someone is in as a prisoner and someone who is not a prisoner seems to me a quality that is useful in judging.
If you look at President Obama's statement, then Senator Obama's statement on the floor on the Roberts nomination, he specifically said that he was referring to the 5% of cases where the law does not supply the answer. So to him, in those 5% of cases, the heart, the empathy was supplying the answer in the case. And I think that's where it, for me, gets to be problematic.
Well, but let me ask you, I agree. None of us want, I hope none of us want a justice who is results-oriented, as I feel many are today. They see what result they're going to come, whether it's through empathy or whether it's through empathy or ideology, and then they write the law to justify it. We shouldn't want that. We should want judges who fairly and honestly try to decide what the law is and apply it. But there are 5 to 10 or 20 or 25% of the cases where there are no clear answers. What should a judge fall back on at that time? And I don't think it should be political ideology or anything. Certainly a sense of sympathy or a common, at the end, maybe you just say, what is fair here? I mean, would you?
No, see, I don't think so. I think, sure, there are cases where there are hard cases, and those are the kinds of cases that the Supreme Court grants, where you might have a circuit split because you've got 3 circuits going one way and 3 circuits going the other way, and perhaps both sides are equally plausible answers as a legal matter, and so sure, you've got no clear legal answer.
What decides it?
So then the judge exercises judgment. They look at all the precedents. They look at whatever legal authorities there are. They look at the arguments, and they make their best. They exercise their judgment to make a decision. Now, I don't subscribe to the idea that when you have 2 judges on 2 different sides of the case, that one of them is engaging in judicial activism or something. No, I think you can have 2 totally divergent decisions that are both based on legitimate rationales, or rationales that are based on someone's interpretation of the law, as opposed to, I just want to go this way today because it's in my, that's how I feel, or that's what's in my heart. I mean, that's
Let me
the
give you a
problem.
simple example. Issue came before the court, pretty minor case, whether systematic racial discrimination in the selection of the foreman of the jury should result in overturning a conviction. In this case, the jury pool was itself was not racially exclusive. But the clerk of the court testified that she thought it only appropriate that a white person be foreperson of a jury. So she always chose, the clerk got to choose the foreman, and she always chose a white foreman. And the defendant is convicted. And the government argues that, of course, the standard was wrong and it was unlawful for the clerk to have done this, and perhaps she should be enjoined from doing it in the future, but there's no reason to overturn a conviction because the foreman actually has no legal authority that gives the foreman any role different than any of the other jurors. And the government is making this argument. And Thurgood Marshall says, counsel, when I was a boy heading out to my first job, my father said to me, there is one rule. You have to do what the foreman tells you. And he said, when a juror like that hears that this person is the foreman, they've been told you do what the foreman does. So this was like news to the rest of the court, that there was this other meaning. That's what I mean about having experience, so that I do think it would be good to have a broader range of experience on the court. Being a judge doesn't preclude that experience. A couple of years as a judge doesn't undo the experience one has gained. In fact, ironically, I think the 2 justices who have brought a broader range of experience to the court, Thurgood Marshall and Sandra O'Connor, more than any of their recent colleagues, both happen to have been judges at the time they were nominated to the court. But they had rich experiences, Thurgood Marshall leading the decade struggle against Jim Crow and Sandra O'Connor is in politics, as the majority leader of the Arizona State Senate. I think they both brought a richness of perspective that comes not from the fact that they didn't lose when they had spent a short time as judges, but I do think that. Just one more point on experience. I think the notion that the argument that you could vote against Elena Kagan because she doesn't have the requisite experience strikes me as an argument born of sheer desperation. The idea that someone is lacking in credentials who has been Solicitor General of the United States, Dean of the Harvard Law School, runner-up to be president of Harvard University, and has served in policy and legal positions in 2 presidential administrations, is a pretty lame argument, in my view.
So this is a fascinating discussion, but I'd like to move us on and ask the panel to, yeah, I've lost control, I think. Ask the panel to speculate, I admit speculate, but you know, Elena Kagan is perhaps the unusual lawyer and law professor in the degree to which she has people skills. She's famously good at soothing egos and bringing people together. At least she seemed to have done that very well as dean of the Harvard Law School. So there's been some question, and I think Obama suggested this as well when he described her as someone who's a seeker of common ground, that maybe she would be capable of building coalitions while at the court. And yet we also know those are 8 people with very well-established views on issues and egos themselves. So do we think it's possible that she could actually build coalitions and maybe shake up the court in a way that another justice, or maybe even Justice Stevens, did not?
Well, can I just say on that, I really, as I said, I don't know her, although that's her reputation. What I tried to point out in my little presentation is that was one of Stevens' skills. He was able, I mean, he's very good at seeing where things are going and trying to build a coalition. There's no doubt in my mind that he was critical in setting up the Boumediene case so that Kennedy could take it at the right time and vote in a way that Stevens thought he should. And I think, and actually I like Kennedy's style in doing this, but that is a skill Stevens definitely had. Part because of his years doing it, and because of his age and his natural skill in dealing with people. So I hope she has it.
It's important to know why she's able to develop coalitions, as she clearly did at Harvard Law School when she brought the ideological wings of that contentious faculty together and broke the logjam on faculty hiring and made the students of the Federalist Society as happy with her as those in ACS. It is not just coalition building. It is her single best quality, which is that she is a listener. And those who have worked with her in the Solicitor General's office and elsewhere have spoken independently of one another, have said, when you take a position that is something that Elena disagrees with, she wants to know why you think what you do. She's genuinely interested. So if it's a different position, she wants to know, how is it that you come to that position, so that she can really understand it and be in a position to shape her views if she is persuaded. And that makes one a very influential colleague and leader, because one's colleagues think that you have really made the effort to understand why they have come to the position they come to. And if you're not just pretending to want to understand, but as I'm certain is the case with Elena, you really do seek to understand, then you are in that person's space where you can say, given that you have all of those other foundational views, here is how I would argue to you that that ought to lead you to agree to the following resolution. And that is an extremely important skill that she has as well as anyone that I know.
She's very smart and very likable, and so I think it's possible. I guess what I don't know is, now, so Stevens clearly very good at that. Part of his success has been a result of his understanding of the procedures and you know, the ins and outs of how the court works. I'm not enough of a court historian to know whether he was as good when he first got on the court as he became later. So perhaps Kagan might get there once she gets in there and understands the procedures of the court better. It's hard to say.
All right. So I want to sort of switch subjects now and ask about a very specific subject, which is sure to come up at the hearings, which is her position on military recruitment while Dean of Harvard Law School. She's been called a constitutional sphinx, someone who has not stated her opinion on a lot of issues, and yet on this issue she clearly did. She called the military's don't ask, don't tell policy a profound moral wrong, an injustice of the first order. Be interested to hear how the panel thinks she's going to respond to those questions at the hearing, and what either a defense or critique of her position at Harvard would be.
Well, I don't think she's going to have the guts to, as Walter said, go down flaming by answering these things. So,
Well, Rachel said she needs to answer the question about the Solomon Amendment because
I think it'll be hard for her not to.
Not to. Good point. Excellent correction. Because in that instance, she was the client, not the lawyer. I was the lawyer. Am responsible for the only difficult issue that Elena Kagan seems to have. First of all, I think the critique that there is anything in this that shows that she is anti-military is utterly without foundation. She doesn't have an anti-military bone in her body, as the testaments of those who were veterans, military veterans at Harvard Law School during her deanship will manifest themselves. She came into office as dean with an anti-discrimination policy in place at Harvard Law School that prohibited discrimination on the basis of race, gender, national origin, religion, and sexual orientation. And no one disputed the fact that, including the military, that they didn't comply with that policy, which was a limitation on the ability to make affirmative use of the services of the Career Placement Office. And under her predecessor, it was understood that the military was not able to use the career services offices because it would not sign the form that says we do not discriminate in our hiring on these bases. In fact, she provided military access to be able to recruit students, and indeed, but once the military said they were going to cut off funds, she understood that overrode the school's anti-discrimination policy, and the career services offices were once again available to the military. Then when the Third Circuit held that the Solomon Amendment, which precluded any federal funding of institutions that, quote, discriminated against the military, refused to give the military equal access. When the Third Circuit ruled that that was unconstitutional, the anti-discrimination policy came back into play. And she enforced it once again as her Republican conservative corporate predecessor, Robert Clark, had done as dean, until the Supreme Court ruled that the Solomon Amendment was constitutional and that it allowed military access notwithstanding non-discrimination policies. Then she went back in compliance with that. But there was never any anti-military aspect to this application of the anti-discrimination policy at all. So I think that's the only side. She was outspoken in support of the dignity and rights of gay servicemen and women, and found the policy abhorrent, and that does give a one sense of her social views on the issue, and that's fair enough. But there's nothing about favoring the rights of gays and lesbians that makes one anti-military. Indeed, that's now the position of General Colin Powell and members of at least some of the members of the Joint Chiefs of Staffs and other military leaders.
Well, just really quickly, I think what is going to be asked, a few things. One, when she made the statement about it being a moral injustice, that sounds like a statement of personal views, so I'm sure she will be asked about that because it's much harder to avoid questions about things you personally opined upon in the past. So that's one thing. Then she signed on to the brief, and that makes a legal argument about the unconstitutionality. So again, she'll be asked about her decision to do that and why she thought that was the right legal position. Now, Walter knows the history up there better than I do, but my understanding is that the Third Circuit, the injunction against the implementation of the Sullivan Amendment never went into effect, and so there was this question about whether, she elevated Harvard policy over federal law when there was no binding judgment there, so I think she'll be asked about that. But, I'm sure that, I don't know how she's going to answer any of those questions. So.
Sorry. Yeah.
No.
Well, my last question for the panel, and then I'm going to open it all up to questions from the audience. But my last question for the panel is, I have the perception, and feel free to disagree with it, but that she's getting a lot less attention than Sotomayor did, that the public is generally maybe a little less enthusiastic, but also just paying less attention. Maybe it's current events, maybe it's something about Elena Kagan, but it just seems like this has not captured the public's attention the way other nominations have. And I'd be interested to know, first, if there's a general agreement, but if there is any speculation as to why the public doesn't seem to be tuned in to this nomination.
Well, I have the same perception. I think at the end of the day, it's very hard, as it was with respect to her nomination as Solicitor General, for people to stand up and say that the dean of Harvard Law School isn't qualified to be on the Supreme Court. And I was out recently with some very conservative people in Colorado, and God, who I think get their news from Rush Limbaugh, and but at the end of the day, that argument seemed to denude them. They felt there was nothing much I could say. Now, maybe I'm wrong.
I think the public debate is less about qualifications than it is about judicial philosophy, and I guess perhaps because there aren't a lot of, silver bullets out there or whatever to grasp onto that indicate her judicial philosophy. Maybe that's why people haven't gotten as interested in the public.
And maybe her personal story isn't quite as compelling as Sotomayor's. All right, well, so why don't we open it up now to questions from the audience. I'd like to first get questions from the press, and after that, we'll open it up to everyone else. Yes. Yeah, and I'm sorry, please wait for the microphone to get to you, and then let us know your name and your affiliation.
Sure. I'm Mike McGough from the LA Times editorial page. I had a question for Walter about the theory that nominees should be forthcoming. Is a corollary to that any senator should be free to vote against a nominee he or she disagrees with? And if that's the standard, how can that be reconciled with the sort of Lindsey Graham standard that elections matter and the president is entitled to some deference?
Yes, it does lead to the notion that senators should be free to say that this is not a person that I would choose. And my response to Senator Graham is that senators are elected too. And whoever has the president, whoever controls the Senate, I've had the same view that senators are fully entitled to take into account the same range of considerations that presidents do, and that presidents most certainly take into account political and social views, as you can see by looking at every nominee in the 20th century.
May I ask a follow-up to Walter?
Sure.
If you were a senator, though, would you pay deference to the fact that even though I disagree, this man was appointed by a president who won with 58% of the vote?
No.
Okay.
But let me say that is my own view. I think if I were a senator, I would feel that I should go along with what the institutional practice has been, and whether it was a senator, a president of my party or not. My view, which I think is clearly the correct one, has been rather emphatically has been largely rejected as a matter of institutional practice. So that you fit you. I express views as a law professor about the president's power to send troops into combat that were not the views that the federal government had taken from the time of Robert Jackson forward. But as head of OLC, I felt I had to fit into the tradition of what the executive branch view had been on those issues. So there's not one's own professorial view shouldn't determine the outcome.
Yes.
Hi, I am Kim Atkins from Dolan Media. If the view that so many people hold, including General Kagan, is that nominees should be able to be more forthcoming and there should be more substantive dialogue during the confirmation hearings. What's the solution? How do we get there? I mean, that hasn't happened since the Bork hearings. So,
here's one reverse answer to that. I am concerned that the confirmation hearings have now begun to determine the kind of nominees that we have. There is an expectation that the nominee will not express, views at the end of the day, but that they will be able to discuss Supreme Court precedents in significant detail. You've been involved in those preparations, Rachel, and there are what would you say, 50 cases that you think a nominee is expected to be able to discuss?
More. I mean,
More, maybe 100. A briefing vote probably has 100 cases, and the nominee says, well, the court has held this, the court has held that. And that seems to be everyone's expectation. I think that terribly distorts the kind of person that ought to be the nominee. If it were, for example, Janet Napolitano, she can say, I've been governor of the state of Arizona. I mean, I was attorney general, but then I was served 2 terms as governor. I've been head of Homeland Security. I don't know any of these cases, and nor do I think that there should be a 2-week or 1-month cram course as if I'm taking the bar exam. But, if you ask people like Earl Warren or others or who had not been judges or professors, they're going to say, well, I've heard of Brown and I've heard of Roe, but those other 98 cases, I don't know what. I'll think about those issues the way a lawyer does when I get to the court. I'll approach him for the first time. But I think now we have this expectation that is driving us towards the professorial/judge model of nominee, because we expect people to do this instead of naming the governor of a large state. The court that was sitting in 1954 had 3 former U.S. senators. The governor, the most popular governor of California before Ronald Reagan in the 20th century, and Earl Warren had been his party's vice presidential nominee. People who had never been judges, only one who'd been a professor, but that professor spent his time advising Franklin Roosevelt on how to go about entering World War II, not grading blue books at Harvard. So that is, I think that court was too full of politicians, and it was very useful when Eisenhower named John Marshall Harlan the New York Bar, then a Second Circuit judge, who brought a sense of professionalism and craft to that court that was useful. But we've now gone all the way the other way to have 100% sort of academical court.
Here's the thing. I don't necessarily disagree with you. I don't think that a Supreme Court nominee should have to know every case out there, although I do think they should have some facility with constitutional issues. But the problem for you with that argument is that if you nominate someone like that, they won't be able to answer questions about their views on the cases that you want them to answer. So it's not that they won't, it's that they won't be able to.
I'd like to answer their views on social issues. What do you think about abortion? What do you think about affirmative action? What do you think about gay rights? What kind of person? What are your views? Hard questions like, what do you think should be done about? Should public schools have rules against girls who use Muslim, headdress? Where do you come down? How do you think about that? The pros and cons of that issue. So it's not necessarily, legal issues that I would have them talk about, but I think I always thought back in the day the names I would submit that were never on the list were, I thought Republicans should consider Warren Rudman, Democrats should consider Lee Hamilton. I thought they would each bring something to the court to name people who are now beyond it.
I want to say something about this. I really do agree with you, Walter, and I thought you said it very well. I think the hearings have become a joke, not because people don't answer questions, but because what they do is engage in almost a law school exam to people in the Senate who don't even understand really what they're talking about. And to the general public who looks at it and says, oh, wasn't Roberts brilliant the way he talked about those cases? Right. And I say, but that doesn't say what's going to happen in the future. And there's something so good. I would like to see somebody, as I said, not a professor and not a judge, who may be a practicing lawyer and who knows how pompous they both can be, and says, I need to cut through this and try to get to the answers. I'm not sure exactly what questions they should or shouldn't answer, but these things have become a joke, not because they avoid questions, but because of the questions they answer and the way they do it. Well, it's like a law school exam.
There's no capacity on the part of any member of the Senate of any party that I've ever seen to really ask follow-up questions. I mean, this was shown by one famous incident involving a lower court judge, so it wasn't on national television. I won't name the senator, but the senator is reading the questions prepared by staff, and the senator reads the question to the nominee, and the nominee answers, and the senator then looks down and says, if he answers yes, ask him. The other thing I think we could all agree on is that the late Mary McGrory went to one of these hearings and was dying to learn about the nominee and was so frustrated because she heard senators talk for the entire morning. And she said there should be a banner posted on the back wall of the hearing room so that all of the senators are viewing it all of the time. It runs all the way across the back and it says, "This is not about you."
Hi, I'm Mark Walsh. I cover the court for Education Week and some other publications, and I'd like to direct this to Rachel. In the first batch of papers that came out on Friday, it seemed to be it's mostly stuff that Elena Kagan received, but there were some handwritten notations, and presumably we're going to get some that one presumes that she actually did write memos and emails in her White House jobs. But I'd like to just ask you, as someone who shepherded the Roberts nomination and some of his memos were at issue, to perhaps draw a distinction even between her counsel's job and her domestic policy job, which, from what came out Friday, there's a lot of give and take. There's a lot of just issues that like Piscataway case that just interesting stuff, and that's less in the role of a lawyer giving counsel. That's do you draw a distinction on those and what that might tell us about her for the job?
Well, boy, yeah. I mean, when you're in well, here's the thing. Even when you're in the White House counsel's office, and I was in the White House counsel's office, there is some room to express your own views on issues. I mean, you're not. That job it has a legal function, obviously, but there's a lot of its mediating disputes between agencies and trying to find a solution to a problem that has a legal aspect to it, but also has a policy aspect to it. So when you're in the White House counsel's office, your work is not purely legal. So there may be documents that reflect her views on policy issues or reflect her own personal views on legal issues. I mean, I just don't know what's going to be in there. So it's possible you'd find something interesting there. And sure, when she was at DPC, presumably she would be expressing her own personal views, but you have to remember, as Robert said, as she said, and as is true, when you're a staffer in the Domestic Policy Council, you don't get to just like kick your feet back at your desk and think big thoughts about policy issues and what would I do if I were the president. No, you have a president and you know what he thinks about all the big issues of the day, and you work within the confines of that. So I have no doubt that she will talk about that when she's trying to deflect questions about things that she wrote in the White House.
I think we can take questions from folks aside from the press right now. Yeah.
I would like to ask I'd like to ask Mr. Wilner, if the president says we are at war and we are at war against Al-Qaeda. Now, during World War II, German prisoners of war were not subject to have habeas corpus hearings. Do you believe that troops, for example, enemy troops that are captured in Afghanistan would then be entitled to habeas corpus hearings?
That's a question that goes back on history. No, wait a second. God, when everybody used this World War II analogy, you didn't need many hearings when you picked up somebody in a German uniform. You knew he was an enemy combatant, didn't you? I mean, you didn't need hearings. And we had millions of prisoners. They were all dressed as uniforms. But the administration said that because I picked you up and you weren't dressed in a uniform, you were a bad guy. Well, I don't know whether you're a bad guy. It seems to me we need to make some determination about that. That's one issue. So if you just picked up people and he was turned over for a bounty and he was dressed in a suit, the idea that the president picked him up and said, look, my decision is final. You can't question it. That's what we're challenged. a guy like you picked up in a suit. So I'm trying to empathize with your position. There's another question is, can you pick up with just defining it, and this doesn't have to do with Elena Kagan, but it may be very important, so what she talked about. We have laws of war which allow you to pick up a combatant, whether you call him illegal or a combatant, and hold him to the end of that combat. The question is, how far does that extend? Clearly, you can pick up people fighting in Afghanistan and hold them as long as that goes on, or pick up people in Iraq and hold them as long as that goes on. But could you pick up a foreigner in London to say that that person supported it, and I can hold him forever, him or her forever, under the laws of war without a trial, without a charge? My own view, and this is the next question that's going to come up, and Elena Kagan's view on this may be important. My view is that international terrorist is an international criminal. And the criminal laws have both the ability to catch these people. You can even use military forces to catch criminals. And our civilian courts are not only adequate, but best able to charge and convict those people because we have an unparalleled success rate of convicting terrorists when we bring them to our courts. I'm not so sure otherwise. So that's the issue. I hope that was helpful.
Additional questions?
Yes. First, actually, Professor Dellinger, and then anybody who wants to argue with him, based on the cases that we've seen over the last 10 years or so, from the hanging chads of Florida to immigration issues to the different things that are before us, the polarization of the court, and, you know, it's probably always been political from before the first day, but what seems to be a more political, more harshly political environment, is it working? Is the system working? The differences, you know, even between, you know, the different circuits and all.
You know, that's a very good question and a very hard question. Is the system working? If you look at the degree of polarization on the court, the degree to which the court divides in such predictable 4-4-1 ways. And I do think that's troubling. That when I first started engaging with the court as a professor, there was a period of time when the court included at least three of the following four people: Potter, Stewart, Byron White, Lewis Powell, Sandra O'Connor. Stewart, White, Powell, O'Connor. You could not get a majority of the court without persuading a couple of those justices that you were right. And almost no matter what your bottom line position was, if you had a good argument, you thought you've got a chance that there's at least a three in the middle: White, Powell, Stewart, O'Connor, and you may think there's no way I'll convince, you know, Brennan Marshall of this or Justice Scalia of this, but there's this strong, and that's gone from the court. And it would not have been the case when I was a young professor that you could say, even in a very contentious case, that the outcome was this and the vote was 5-4, when you could have, with absolute moral certainty, have identified the 5 and the 4. And that, I think, is a cause for concern, and I have no idea what the solution to that would be.
I just say I agree totally. Now we prepare to get Justice Kennedy, and it's a shame. I think the solution, with all respect, Rachel, I don't think it's because a lot of those 4 on the left now. I mean, I was always amazed. They're Republicans. It's almost a changing. I think it is a result-oriented, doctrinaire way of thinking on the other side, and I think the only way is replace them. Yeah, honestly, I'd replace them on both sides. I mean, I think you should go in and you should argue very objectively for justices who really interpret the law, as I say, to look for justice. And I always look back. You know, if you read the history of the court, some of the most interesting cases were the cases dealing with the constitutionality of minimum wage laws. And it was extraordinary to me how people can write very intellectual opinions supported by precedent that minimum wage laws were absolutely unconstitutional because he interfered with the individual's ability to negotiate for himself. And here was a law to protect that individual. And finally, when you saw Brandeis and others saying, this makes no sense as a matter of justice, that you were interpreting a law to protect someone against his interests. You've got to look and say, you know, sometimes you do come down to these decisions. The law can be a blinder to what's right. And people, when you got those justices you mentioned in between, all of them were seeking what is just. So I think we need to get back to that.
Can I give a quick response? I mean, if you go down that road, then the inevitable consequence is that Supreme Court confirmation hearings get even more contentious than they are now, because then there's got to be an inquiry into what the individual's personal vision of justice is. And so, you know, so I'm a Republican. I'm a member of the Federalist Society. I'm sure that scares all of you. So would you want me on the bench to, impose my sense of justice? Okay, right? So
and be more contentious but more relevant.
Maybe, but I'm just saying you would really have to get down into. It would be unbelievably contentious, much more so than
and I think
that's
actually a good segue to a question I had for the panel about the age of the nominees creeping lower and lower, and Tom says replace them. Walter talks about this being the moment where the democratic process kicks in and then the judge has life tenure. Are we concerned about the fact that judges and justices are now serving for 35, potentially 40 years?
Well,
is that a problem, and should we try to deal with it?
Holmes was appointed at, 64 and served for 30 years. So, I don't think we should preclude old people, particularly as I've gotten older. It's very
Well, I'm older, and I would rule out, older judges. I think people died relatively young in 1787. So life tenure did not mean what it means today. And I would certainly think that we should have a 15, 18, I'd say 18-year maximum term of Supreme Court justices, precisely to avoid the temptation to name young people to the court. I don't think anybody should be on the Supreme Court who has not yet had his or her midlife crisis, where I think you gain some empathy with the world. And ironically, being named to the court at a young age, and I will single out William O. Douglas, who I think was an absolutely terrible justice. Always voted the right way, usually by my lights, but I think was a very poor justice. He was appointed at 39. Being appointed to the Supreme Court at too young an age is something you never outgrow, because you're insulated from the experiences of the world. You are really in a mausoleum with a set of adoring law clerks and an assistant, and you never, have to go through the struggles of life, at least in the professional world. So I think being elected to the Senate at too young an age and being named to the Supreme Court at too young an age are something you never outgrow, and it's too bad, and it's a shame we don't have. I think it's hard for presidents to predict the out years anyway. I mean, Roosevelt named Frankfurter and Black because they both agreed with the power of the national government to regulate the national economy, but then they differed sharply on other issues that Roosevelt could not even have imagined on the out years. So I think there's not that much percentage in naming very young judges.
And if I remember correctly, Chief Justice Roberts, before he was appointed, had talked about term limits for judges, but then he said he was young and foolish when he said that, when asked that at his confirmation hearings. Other questions?
Justice Thomas just came and visited my law school in the early spring, and someone asked him the question about how he felt about confirmation hearings, and I think it was a pointed comment, but anyway, he happened to say that he thinks that confirmation hearings anymore are becoming very disrespectful to justices, and whether or not the senators may agree with their policies or whatever, that ultimately to reach this point of prestige in their careers, they must have done something right. You know, they're intellectuals and they're smart and they've gone to good colleges and that sort of thing. So Justice Thomas said that, you know, on both sides, these proceedings are becoming very disrespectful to justices who have had successful careers. So I guess, Ms. Brand, I especially want to ask you how you feel, first of all, about that comment, and second of all, since Elena Kagan doesn't have such a past, you know, of decisions that could be disrespected, how do you think that might be affecting her confirmation hearing process?
I don't think that would affect the level of personal respect that would be accorded her in the hearing. I don't. I mean, you know, people are always asking about how political the process is and how bad that is and everything. I'm not sure whether the process is any more political than it was, because you look way back to George Washington, who had a nominee rejected for his opposition to the Jay Treaty. I mean, you know, there were political things. I think that what the part of the process that I don't like is when the questions sometimes take on an ad hominem feel, when senators sometimes ask questions that suggest that, you know, your record in a Title VII case might mean you're sexist or something like that. I mean, I do feel like when there are questions like that, that's unfortunate. And maybe that's what Justice Thomas was talking about. I don't know. I've never heard him make that comment before. But I think with the Sotomayor hearing, I feel like she was treated with a fair amount of respect. I don't know what other people think, but hopefully we'll see that with Kagan as well.
Can I answer? You know, and I'm serious when I started, although I agreed with Walter about some of the things. I think these hearings are a joke. And I question, and by the way, starting out, I read recently about the confirmation hearings of Justice Brandeis, by I think everyone's agreement, one of the 3 best justices ever to serve. And they were horrible, just horrible, because he had taken on issues because of who he was and all that. But I really look at what the role is of the Senate in advising consent with respect to justices. I disagree with Walter. I would defer to a president's pick, so long as that person is competent intellectually, not immoral. I think he has the right. I think he has the right to move the country forward in those sorts of ways. I mean, if you have a hack, you can put it on. But other than that, if they agree or disagree with you on certain issues, if that's a judgment, then it's always a party line vote, basically. And I don't think that's the way it should be. I think the president has a right to choose a competent justice. I would have voted for Bork. I thought he was a very competent guy. Disagreed with him. I mean, you know, I really disagreed with him. I mean, I was tempted to vote against Roberts because he answered the question so well. I hate these smart-ass guys answering well. But anyway.
That was all Rachel Brand's
that was Rachel.
She taught
Not true.
My question is, in a way, when I come down to it in the end, I hate to say it, but I agree with Clarence Thomas. There, Walter, that throws it to you.
I'll pass.
Okay.
And I think this will be our last question.
Okay, this could be a good one. This is for Mr. Dellinger. So has Elena Kagan had a midlife crisis? And if so, could you tell us about it or something about her? Because one of the things I think is interesting about her confirmation, her nomination, is that her personal life, I mean, aside from some, you know, kind of fringe stuff, there's very little about her personal story, which is very different from with Sotomayor. And will there be more details about her life coming out as part of the confirmation process, or is this going to be a very strictly legal interrogation?
I think she will talk about her experiences growing up, the kind of law her father practiced for individuals, teachers, people like that, what she learned from her mother. I think she's not easily given to talk about those issues, but I interviewed her at Georgetown maybe a few months ago after she became Solicitor General, the Corporate Counsels Institute. There may be a tape, but I pushed her to talk about what she learned from her mother, what she learned from her father, and it was very affecting on her part. So I think you will hear about the kind of values that she learned from them. I hope she will talk about that at her hearings, and you will see more glimpses of her views. It's amazing what comes out. Rachel and I were both talking about the presidential papers that are kept highly confidential, and now they're just pouring forth. I wrote a memorandum about what to do in the Piscataway affirmative action case involving the layoff of a white teacher that I considered highly sensitive and confidential for the Attorney General and the President. And Elena writes on it, this is exactly right as a matter of law, as a matter of policy, and as a matter of politics. And there, the PDF is out there, which I never expected to see. And I never knew that she had seen it or that she had written a comment on it until those papers were released. But that's an example of how people will take her as having incorporated what I said in that memo by reference and be seen as her views on affirmative action. So I think some of these things will gain some attention. And from historians, it gives you a window into how the Solicitor General can interact with the White House that otherwise would not have ever been public in any other form. And Rachel and I agree, we would have resisted releasing documents like that, presidential decision documents of that kind, but they come pouring forth in response to a Supreme Court nomination. You can't be seen as hiding anything.
Well, and eventually they'd come out anyway under the Presidential Records Act. Pretty much everything in the White House comes out.
Right.
All right, so any final words from our panelists? All right, well, thank you all for coming, and thank you to the panelists. And ACS.
Good to see you. Are you enjoying it?